This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Speaking of stupid things that have huge consequences, Ohio has said that a bar applicant who smoked marijuana but didn't disclose it cannot be an attorney, at least not this year. Let's see what is going on here. This is an opinion of the Ohio Board of Commissioners on Character and Fitness of the Supreme Court. So this is when you apply for your law license, you have to take the bar exam. Well, you don't get to take the bar exam until you have completed sort of some pre-examination, sort of like an application. And the application includes a background check that is called the Character and Fitness Examination. And it's not a brutal examination as in you aren't brutally subjected to examination, but it is a brutal examination of you, of your past. So you have to disclose everything that they ask for, which includes things like legal actions and arrests and convictions and things like that. So, for example, I've been divorced before. I had to disclose my divorces and any litigation that I was involved in. I think I was involved in like one of those weird class action lawsuits. It might have been like the PlayStation class action lawsuit or something. I think I may have disclosed that. And they're looking for this. It's not that they care that you got divorced or that they care that you were part of a class action lawsuit. It's they want to see how good you are at following the directions and being honest with them. So if you're not honest with them, that's a big deal. Applicant Dylan Phares of Toledo, Ohio, is a 2019 graduate of the University of Toledo College of Law. First, congratulations, Dylan. That's a lot of hard work. Second, if then he's going to be denied his bar exam and being an attorney, at least for an entire year, that's a whole year of student loans that don't get paid off unless you have a job and all that. It can be a real big burden. That's what happened to me when I graduated and got my law license. That was the 2008 market crash, and it was still going on when I got my license. And there was no prospect. So I didn't work very much for the first couple years of my law career. And here, this person's going to have this imparted on them for a year. He applied to register as a candidate for admission to the practice of law in November 2017 and later submitted an application to take the July 2019 bar exam. Phares was interviewed by a 2-member panel of the Toledo Bar Association Admissions Committee in August 2018, and the committee issued a provisional report recommending that his character, fitness, and moral qualifications be approved. The Board of Commissions on Character and Fitness, however, exercised its authority to investigate his application on its own, based on his failure to disclose that his employment with Ohio Link, the operator of a halfway house in Toledo, was terminated in 2016 as a result of his testing positive for marijuana. After receiving testimony at hearings in May and October of 2019, a 3-member panel of the board issued a report finding that Phares does not currently possess the requisite character and fitness to sit for the Ohio bar exam, and recommending that we disapprove his pending applications but permit him to reapply for the July 2022 bar exam. The board unanimously adopted the panel's report and recommendation. We adopt the board's findings of fact and disapprove Phares' pending applications. We will permit him to reapply as a candidate for the July 2022 bar exam or a later bar exam. So that's 3 years. That's effectively a 3-year suspension from the practice of law, except that he was never granted the practice of law to begin with. So it's effectively like that. So one simple act of dishonesty, and he loses 3 years of his career. Facts. In Phares' application to register as a candidate for the July 2019 bar exam, he reported that he had been employed by Ohio Link from March through August 2016 and that he left that employment because he was starting law school. He answered no to another question that asked, have you ever been terminated, suspended, disciplined, laid off, or permitted to resign in lieu of termination from any job? In response to an inquiry from the National Conference of Bar Examiners, however, Ohio Link reported that it terminated Phares' employment in August 2016 and that it would not rehire him. Phares and his Ohio Link supervisor, Beth Miller, offered similar accounts about the incident that ended his employment. As an Ohio Link community reentry specialist, one of Phares' duties was to check on clients who were serving home detention. On Monday, August 8, 2016, Phares had visited a client and was returning to the office in a company vehicle when he was involved in an accident. He called his employer, and Miller drove to the scene and waited with Phares for the police to respond. After police completed their investigation, Phares and Miller returned to the office. During the drive, Miller informed Phares that pursuant to company protocol, he would be required to provide a urine sample for a drug screen. Phares said nothing in response. Upon their arrival at the office, Miller handed Phares a cup that was designed to provide an immediate result and instructed him to provide a urine sample. Again, he said nothing. The urine sample that Phares provided tested positive for marijuana. As Miller was about to pour the urine into a second cup to verify the result, Phares told her that the second test would also be positive because he had used marijuana the previous weekend. I wholeheartedly disagree with destroying someone's career because they drank alcohol or smoked cigarettes or smoked marijuana on their own personal time and did so in a way that doesn't affect their employment. But I can't deny that employers have the legal right to deny people employment under those circumstances. And I mean what I said. An employer can choose not to hire people who smoke cigarettes, who smoke marijuana, who drink alcohol, who watch Ren and Stimpy. As long as it's not a protected class, race, sex, gender, origin, familial status, as long as it's not one of those protected classes, employers can discriminate on it. So even though it's, in my opinion, really, really stupid on the Ohio Link's part for discriminating against Mr. Phares for smoking marijuana on his own time, I can't deny that they have the right to do it. Phares's and Miller's accounts of the incident thereafter diverge. According to Phares, Miller told him that although he tested positive, he could remain employed with OhioLink provided that he take a substance abuse course. He testified that he told Miller that he was not interested in taking the course because he had already informed OhioLink that he would be leaving shortly thereafter to start law school, and that he was quitting his job that day. He also testified that he never had any further communication with Miller, her supervisor, OhioLink director Lisa Banks, or anyone else at OhioLink. Although the record shows that an OhioLink human resources officer mailed Phares a termination letter on August 11, 2016, Phares testified that he did not receive it, perhaps because he had moved or because the letter's mailing address did not identify his apartment number. Miller testified, however, that once Phares tested positive, she informed him that he would be on suspension until further notice. She denied ever having told Phares that he could remain employed if he took a substance abuse course. Instead, she told him that he would be suspended and that someone at OhioLink would have to get back to him about what the next steps would be. Miller expressly denied that Phares informed her that he was quitting or that he was not ever coming back to OhioLink. And in stark contrast to Phares' testimony, Miller testified that he attempted to contact her at least twice during the week of the accident to ask what was happening and whether she had heard anything about his suspension. Banks testified that during the week of the accident, she had 2 telephone conversations with Phares and that he questioned the validity of OhioLink's drug testing protocol. During one of these conversations, Phares told Banks that he would be coming in to speak with her, but he never met with her or responded to the numerous messages she left for him. According to Banks, Phares never informed her that he had quit, and someone from OhioLink's Human Resource Department eventually informed her that Phares had been terminated. Based on Miller's and Banks' testimony, the board concluded that Phares was suspended from his job on the day of his accident and later terminated based on his failed drug test. Although the board acknowledged that Phares may not have taken affirmative steps to remain at OhioLink because he was going to start law school in just a few weeks, it found that his registration application grossly mischaracterized what actually transpired. Phares then compounded the problem by giving false testimony to the panel at both his admissions hearings. So there you go. Maybe it could have just been a misunderstanding, and maybe the board would have overlooked the false written statement with an explanation that he thought that he quit and they thought that he was fired, and maybe he never looked at the letter. It's plausible. But then he gave false testimony to the panel at both of his admission hearings. Indeed, the board found that Phares made the conscious decision to maintain that he had quit his job and that he had not intended, initiated, or engaged in any contact with anyone at OhioLink since the day of his accident, despite Miller's and Banks's independent testimony to the contrary. An applicant for admission to the Ohio bar bears the burden of proving by clear and convincing evidence that the applicant possesses the requisite character, fitness, and moral qualifications for admission to the practice of law. An applicant may be approved for admission if the applicant satisfies the essential eligibility requirements for the practice of law as defined by the board and demonstrates that the applicant's record of conduct justifies the trust of clients, adversaries, courts, and others. A record manifesting a significant deficiency in the honesty, trustworthiness, diligence, or reliability of an applicant may constitute a basis for disapproval. The failure to provide complete and accurate information and the making of false statements may likewise warrant disapproval. Here, Phares engaged in a pattern of dishonesty that began with his omission of potentially damaging information in his November 2017 registration application and his certification that he had answered all the questions in the application fully and frankly. Phares's pattern of dishonesty culminated with his giving false testimony under oath at his admissions hearings in May and October 2019, after he had graduated from law school. On these facts, we agree with the board's finding that Phares has failed to carry his burden of proving by clear and convincing evidence that he currently possesses the requisite character, fitness, and moral qualifications to practice law in Ohio. Accordingly, Dylan Houston Phares's pending applications are disapproved. He may apply to take the July 2022 bar exam or a later bar exam, provided that he submits a new application to register as a candidate for admission to the practice of law in accordance with the rules and is able to establish that he has the requisite character, fitness, and other qualifications. And that is before a whole panel here, including someone named French. So that's really interesting, attorney or Judge French. And that's the Toledo Bar Association and Dylan Houston Phares. So yeah, don't lie on your bar application. You're better off dealing with the negative consequences of whatever actually happened than dealing with the negative consequences of lying about it. Holy mackerel. One of the fastest ways to lose your law license as an attorney is to be dishonest. Really, pretty much in any way. Not necessarily like Liar Liar, Jim Carrey movie, dishonest, like you have to be honest about everything to everyone at all times. No, but with the court and official matters and official documents and things, even private official dealings with the government, you still have to be honest. Can you lie to your spouse? Yeah, you can probably lie to your spouse and your friends and family and stuff like that. That's not really applicable. What's applicable is whether you're lying in the course of your duties to your clients, or lying in the course of your dealings with the government or other officials, or I guess other private parties during like business and things like that too. That can all come into it. So basically, don't lie. It's easier just not to say anything. It's really a whole lot easier just not to say something, or in his case, he should have been honest. Like I said, I have things in my past too, not a marijuana conviction, but other like divorce. I had 2 divorces, so I had to put those on there. And did I like that I had to put that on there? No. Would I have liked to just hide it? Yeah, but who cares? Like, they just looking to see if I'm honest or not, and not whether or not I actually got some stupid conviction from a long time ago or had a divorce or 2. They just want to make sure that you're actually being honest. So don't be like Mr. Phares, and be honest with your board of bar examiners when you're applying, your board of character and fitness examiners or investigators. Got to be honest with them. So that's our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education YouTube channel. Thank you very much to all of you who support our channel on a monthly basis. This would not be possible without your support on patreon.com/ljfrench and sponsors.com/law, and YouTube memberships and Twitch subscriptions and Floatplane memberships. Thank you to the following $50 plus supporters in the month of June: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, HotGrillsInYourArea, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian Hellman, Jay Dixon, Ameknight, Oscar the Phrophet, and HotGrillsInYourArea. And thank you to the $5 plus supporters who are scrolling on that LED panel back there, and in the crawl of the videos that drop, and in the descriptions. I'm Leonard French, your favorite copyright attorney. I love you all. I will see you in the videos that drop. Have a great week. Bye. Drop. Are we gonna have a problem?
Bye.